immigration attorneys at Dickinson Wright. And today I wanted to discuss the national interest waiver pathway to permanent residency. And specifically, I wanted to address some tips for a successful national interest waiver case, particularly aimed for those who might be working in an area of STEM research or an area of STEM work. But before we get to that, let's start with a basic overview of the permanent residency process through employment. So the very vast majority of foreign workers have to go through a 3-step process to achieve permanent residency. So the first step in that process is a test of the job market. The employer, so note that this has to be sponsored by an employer. The employer must place ads and postings as required by very specific Department of Labor regulations. And if in response to those ads and postings, no qualified U.S. workers apply, they can file a petition on behalf of the worker to request certification of that perm or labor certification. This is a pretty lengthy process in terms of preparation. Right now, it's taking about 1.5 years just to get through that labor market test. And because of that, it's a time-consuming process. So one alternative that some folks are starting to consider more frequently in terms of a viable channel to permanent residency is this national interest waiver. So the national interest waiver, what it is it's a waiver of the job offer requirement based on the fact that the foreign worker will be working in an area or will be pursuing work in an area that is of national interest to the United States. So accordingly, if there's no job offer for that position, there's no labor certification requirement, which means that the foreign worker can bypass that test of the job market and proceed directly with a filing with U.S. Citizen Immigration Services to request consideration under this national interest waiver category. So self-petitioning is permitted. It's one of the few categories in which a foreign worker can petition for himself, which is very appealing in many cases. And then it's also considered an EB2 or a second preference category petition. That means that the national interest waiver process is designated for those who are advanced degree professionals or individuals of exceptional ability. An advanced degree professional is one who typically has a master's degree or higher, or the equivalent. And some folks who have a bachelor's degree and 5 years of progressive post-baccalaureate experience can also qualify as members of the professions holding advanced degrees. So there's no definition of national interest in the regulations. So what we have to do to determine what national interest means is to look at case law. And the seminal case that defines what is in the U.S. national interest is a case called Matter of Danassar. And Matter of Danassar sets out a 3-part test for determining if somebody's endeavor is in the U.S. national interest that warrants the waiver of this labor certification requirement. So the first prong of that test is that the applicant's proposed endeavor has to have substantial merit and national importance. The second prong is that the applicant has to be well positioned to advance that endeavor. And then the third requirement is that balancing the interest that the U.S. seeks to advance in requiring this labor market test, which is to protect the jobs, wages, and working conditions of U.S. workers, that on balance, when considering that valid U.S. interest, the interest that the foreign national is advancing actually outweighs that U.S. interest in protecting the U.S. jobs, wages, and working conditions. So In order to understand what those three requirements mean, we can look to the USCIS policy manual. And the USCIS policy manual is a guidebook for adjudicators who are processing these petitions that provides some information to these USCIS officers as to how to weigh certain evidence, what should be considered, how to evaluate evidence. So it's a really very useful tool that you can look at to figure out if your case might meet that EB2 national interest waiver standard or not. And so these next few slides are going to discuss some excerpts from the USCIS policy manual as to how you might be able to show each of those three prongs. So as to the national interest and the national importance and substantial merit requirement, these couple of quotes come directly from that USCIS policy manual. So if the record demonstrates that the person's proposed endeavor has the potential to broadly enhance societal welfare or cultural or artistic enrichment, or contribute to the advancement of a valuable technology of a field of study, it might rise to the level of national importance. USCIS recognizes the importance of progress in STEM fields and the essential role of persons with advanced STEM degrees in fostering this progress, especially if focused critical and emerging technologies or other STEM areas important to U.S. competitiveness or national security. So there is a critical and emerging technology list that's published by the White House, and it lists the current technologies that are considered priorities for U.S. national security, for the economic development and progress of the U.S. So always, when I'm working on a national interest waiver case, I'm looking to that critical and emerging technologies list to see if there are any of those technologies that we might be able to focus on in pursuing a case. So really, there are a lot of things that can be nationally important or have some sort of value to them. It's important to really define that as you work on coming up with a strategy for the case. The next prong is that well-positioned to advance the field of endeavor. And the USCIS policy manual says this: in evaluating whether the person is well-positioned to advance the endeavor, USCIS considers factors including, but not limited to, the person's education, skills, knowledge, and record of success, a model of plan that the person's developed or played a significant role in developing for future activities, any progress towards achieving the proposed endeavor, the interest or support garnered from the person from potential customers, users, investors, or other relevant entities or persons. And then it also says this: USCIS considers an advanced degree, particularly a PhD in a STEM field, tied to the proposed endeavor and related to the work, furthering a critical and emerging technology or other STEM area important to U.S. competitiveness or national security, an especially positive factor to be considered along with evidence for purposes of the assessment under the second prong. So that really kind of opens up the door as far as meeting that well-positioned requirement. If you have a background in a STEM field and are working to further that field, this might be at least a consideration. It might be worth evaluating the viability of a national interest waiver case if the other prongs of the test can be met. So the third requirement is that balancing requirement. And the USCIS policy manual issues the following guidance. And the USCIS policy manual is pretty thorough. These excerpts that are included here are excerpts. So it's worth taking a look at the entire policy manual to see exactly what types of evidence are considered and what sort of considerations are made by officers when reviewing a case. I'm not going to read through all of these, but I do want to touch on the second bullet that says more specific considerations might include whether urgency, such as public health or safety, warrant foregoing the labor certification process, whether the labor certification process may prevent an employer from hiring a person with unique knowledge or skills, whether the person's endeavor has the potential to generate considerable revenue, whether the person's endeavor may lead to potential job creation. So what I like to do also when I'm working on a case is take a look at those specific considerations and talk with the employer or the foreign worker about how they see their role impacting each of those considerations to see if we might be able to specifically make out arguments according to those considerations that USCIS has stated that it will consider.
Hey, Heather, we have a question. So let's say I have a bachelor degree in a STEM field. Can I qualify?
Yeah, most likely not. So the EB2 category, which is where this national interest waiver pathway falls, requires that the individual be either a person of exceptional ability, which has a lengthy list of requirements, or has an advanced degree. An advanced degree typically means a master's degree or higher, or the US equivalent of a master's degree or higher, and can include individuals with bachelor's degrees and 5 years of progressive post-baccalaureate experience. But it would have to be a very compelling experience, in my opinion, in order to qualify. Not to say that it would be off the table. I can think of scenarios, particularly given the evolving state of our technology and economy related to technology right now, that might lead to the consideration of somebody who might have only a bachelor's degree. But I think it makes for a little bit more of an uphill battle.
Gotcha. So let's say I have a master's degree or even a PhD in a STEM field. What about that? Do I qualify?
Yeah, and I think I often hear that question, and it's not black and white. So what you have to do is to go back and look at the USCIS policy manual, go and look back at that matter of Danisar test, and assess whether you think that you have the credentials and whether your work is of sufficient national importance to qualify for this pathway. So quite possibly, you might want to have it evaluated, talk to an immigration lawyer about your chances of success. But just because you have a master's degree or even a PhD in a STEM field doesn't necessarily mean that you have a viable case for a national interest waiver. But that being said, I think that this is a very subjective process. And because it is a subjective process, you want to very carefully craft your case to provide the greatest likelihood of success.
Well, on that note, what can a petitioner do to strengthen a national interest waiver submission?
Yeah, and in thinking about this, I really think that there are 3 very clear things that a petitioner can do to strengthen the preparation of their case. So the first thing that you want to do is you want to define your field of endeavor with specificity. So again, this is a process that waives the job offer requirement. So the test is not whether or not your work or your job or your position is of the U.S. national interest. It's whether you're going to be pursuing something. You're going to be pursuing some goal that is of the U.S. national interest. And the USCIS policy manual gives a little bit of an explanation as to what an endeavor is. And it states that the term endeavor is more specific than a general occupation. So you don't want to say, I am intending to work in the US as a mechanical engineer. That's too broad. What you want to do is you want to ask yourself some questions. You want to ask yourself, what's my goal? How do I think that my work can be impactful? And I want to give just an example of a case, just an example of how we recently obtained an approval for a national interest waiver case for a professor. So we were working with a mechanical engineering professor, and the endeavor was not described as, I endeavor to pursue teaching in my field of expertise and do associated research. Instead, what we did is we looked to the particular focus of the professor's research, and we defined it as researching and developing novel ways to generate power from wind energy through the development of new wind turbine designs, considering the capacity for power production, cost, and use in a non-traditional setting such as urban environments. So you'll see that's a very specific field of endeavor. But what you can do with that field of endeavor is explain how it can be applied across various areas of U.S. national interest. So we can touch on that as to economics. So as a professor, I'm teaching students in this field. I'm teaching students in this field and in an economically depressed area of the state where there might be jobs in wind power. So I'm preparing these students for high salaried careers in this area that's really of need for skilled workers. So we can touch on the economics. We can touch on also the impact for climate change. We can touch on renewable energies. There's so many different areas that we can argue are in the U.S. national interest, which really goes to that third prong of the test as well. And it's not just, is something in the national interest, but we can also use all of these arguments to say that the field of endeavor is indeed so highly valuable in this case because it will outweigh that labor market test interest of the United States. So making sure you really work on defining your field of endeavor is probably the first thing that you want to do once you've determined that you have a viable case and you want to move forward. Ask yourself, what's the goal of the research? What am I trying to achieve? The second tip, use government data and resources and provide statistics and figures to support your claims. So it's a lot more compelling if you can provide a statistic that says the field in which I want to work has a X percent growth rate currently, and it is projected that there are going to be 10 jobs created for every one worker in this field. So you can provide statistics like that. That certainly goes a long way to proving your case. And it's a lot stronger than saying something like there is a skills gap in my field. So use statistics, use data. And I've listed here a few important sources for data. The first is a critical and emerging technologies list that we've discussed earlier in this presentation. And the critical and emerging technologies list is always a great place to start because these are really pre-designated areas of U.S. competitiveness, U.S. national security interests. So it's not to say that just because you're working in a critical and emerging technologies field, that you have a case for a national interest waiver, but it's good, strong evidence, and it's a great place to start. There are also a lot of reports out there as to national strategies on X. So there's a national strategy on advanced manufacturing. There's a national strategy on cybersecurity. There's a national security strategy. And the national security strategy is worth reading because it contains more than just information on, what you might typically think as national security. There are other aspects to U.S. national security other than just, warfare or what you might consider as cybersecurity, other aspects to the U.S. national security. So these are useful to just read through, and they're often very helpful as supporting evidence. We did a case for a operations manager in the food industry who was working on applying advanced manufacturing techniques to production, which would in turn improve food safety and reliability. And we were able to pull a lot of good information from the national strategy on advanced manufacturing. Employment projections, I noted that earlier, those are often very helpful. You can pull those Department of Labor statistics, and it's helpful because these are government produced reports and information and projections. I'll also note the CHIPS and Science Act. The CHIPS and Science Act is a treasure trove of good information. So there are places in that CHIPS and Science Act where government priorities are discussed, where STEM education is discussed. So you can often pull some good information, even if the position is not in or related to, semiconductor manufacturing. And then you can also look at government agencies or other government websites. We've used the EPA, the USDA, the Department of Defense, Department of Labor, Bureau of Economic Analysis. These are all great places to pull reports, to pull data, to pull articles. Sometimes there are grants issued by these government agencies in particular areas. And even if the foreign national didn't receive a grant from the government agency, if there is a grant available in that area because the government deems it to be important enough to fund, then that's useful information to support the case. And then there are also non-government resources. So McKinsey and Company has great reports. There are reports from national associations. So for example, I am working on something for a retail case right now, and the National Retail Association worked together with PricewaterhouseCoopers to put together a report about the value of retail to the U.S. economy. So that's a supporting exhibit that we're using right now too. So you can really utilize these resources to support the case and support the arguments that you're making. And then finally, maximize the value of reference letters. So I often prefer the term testimonial letter to a reference letter because I like to look at it as I am preparing a case for trial and I'm calling a witness. What value can that witness provide to my case? And so each author should be selected carefully so that their letter of reference serves a particular purpose. Reference letters can tie together evidence, they can fill gaps. They should not merely regurgitate a resume or offer general praise, but instead explain why a particular accomplishment was important. Explain why an article that somebody wrote advanced the field, how it's being utilized. How has industry been impacted by a particular research achievement or by a particular publication? And then they can also be used to explain the field. And this is very helpful if you're dealing with something that's complicated and you're providing a lot of scientific data and scientific evidence. You can use a reference letter to really break down that into layman's terms. So those are some of the those are some of the tips that can really help refine the case and make it stronger.
Heather, we have a couple other questions out there. The first one, assuming the foreign worker is successful with the national interest waiver, how does the overall timeline compare with the traditional perm process?
Yeah, that's a great question. And it's a question that we do see a lot. So because you're able to bypass that job market test, and because that job market test takes about 1.5 years, you're able to really start the process by 1.5 years. So this process used to be very appealing several months ago when we were dealing with a very low H-1B selection rate after the first round of H-1B selections were announced. At that time, there was a lot more availability in the EB2 worldwide category. So a lot of folks who might have been running out of time on their OPT, we were looking at them to assess their viability for a national interest waiver case to see if that might be a way of securing work authorization before the OPT EAD would expire. So for them, they were able to get started on the permanent residency process 1.5 years really sooner, because you're able to reach a milestone in that process where you have a priority date against which you can compare the monthly visa bulletin to see if you're eligible to file your application for permanent residency. So a lot of folks were able to file concurrently, or at least establish a priority date earlier. So there is some significant advantage in terms of timing compared to the perm process, though right now, because there are backlogs in the EB2 category, there is still, if somebody's in that situation where they're up against the wall, up against a deadline for being able to secure some sort of work authorization, it still is a gamble in moving forward to try this path, because you still have to be current in order to be able to file for adjustment and then receive the benefits of adjustment of status, such as work authorization.
Oh, I get it. So can someone pursue both a perm and an NIW?
Yeah, absolutely. There's no restriction on that. We recently were able to obtain a national interest waiver approval for somebody who had a prior perm approval. And essentially, this worker wanted to have the flexibility to move into additional roles more quickly. And so the national interest waiver allowed him to obtain an approval that was more open-ended, tied to a field of endeavor versus tied to a particular position, which is what the requirement for the perm process is, and ultimately obtain permanent residency more quickly, while enabling him to pursue additional roles or different roles within his organization. So it can be tremendously beneficial to some folks, and there's no prohibition on pursuing permanent residency through multiple channels.
That's great to know. Any final thoughts, Heather?
Yeah, I think that the national interest waiver is an often overlooked channel, but it's often a very viable channel, particularly for those who are working in STEM fields. And that's due to just the significant backlogs that we're seeing right now across all areas of immigration processing. But, it's also due to the environment that we're in currently in terms of how rapidly certain technology fields are developing. For instance, we have just a huge need for semiconductors, or artificial intelligence is altering life as we know it right in front of our eyes. So we have all of these changes that are happening right now in terms of technology, in terms of advancement, that are really turning a lot of industries on their heads. And so because of that, I think that a lot of folks might want to open their eyes to this process and discuss with their immigration lawyer whether they might qualify, because who knows, it might open up some pathways, or might speed up some processes.
Wow, Heather, that is such great information. I want to thank you for such a great presentation. Thank you, everyone, for joining us today. If you have additional questions related to your immigration processes, any of the topics that were talked about today, please reach out to Heather. Her contact information is in that speaker biography widget. Thanks again for joining us today, and we'll see you next time.